Welcome to Mystery Defense Academy presents Concealed Carry Basics, Part 8, Self-Defense and the Law. A couple of things here. First of all, these are general principles, not legal advice. State laws are unique to each state. Some of this lesson will refer to federal law and occasionally to Utah law, Utah Code Annotated or UCA. If you see that reference, that's what it's referring to. Be sure that you are fully aware of the laws of your state regarding the use of force and self-defense. None of this should be regarded as legal advice. Viewers are responsible to know and understand the laws in their local jurisdiction. Some basic rules of concealed carry. Concealed handgun is for protection of life only. I feared for my life. You don't shoot to kill, that's not the purpose. You shoot to stop the threat. You draw only to protect yourself or another innocent person from criminal attack, which is life-threatening, or which may result in serious bodily injury. You cannot create or contribute to a nuisance, defined as any condition dangerous to human life, such as brandishing, warning shots, not clearly identifying your target, shooting to wound, etc. What to do during a police encounter. While there are many opinions out there, this is what I was taught and what I recommend. Keep your hands visible at all times, on the steering wheel or dashboard. Be polite when you speak to the officer. Good afternoon, officer. Just so you know, I have a concealed firearm permit and I am currently carrying. How would you like to proceed? Comply fully with all instructions given by the officer. If asked, please advise the officer the location of the firearm. Do not reach for your firearm or anything else like your wallet unless instructed to do so. In Utah, you are not required to notify, but it is a good idea to do so. If a police officer asks, you are required to answer truthfully. Escalation and de-escalation of force. So these are 5 steps in escalation and in reverse, de-escalation of force. Confrontation, threatening presence, verbal threats, physical, less than deadly force, and deadly force. For example, you cannot apply deadly force unless deadly force is threatened. The 5 elements of legal self-defense. These are important for the legal standpoint of claiming self-defense. Innocence, you are not the aggressor. Imminence, there's a threat to you right now. Not 2 weeks from now, not tomorrow, but right now. Proportionality, the threat level warranted the use of deadly force. Avoidance, if you have a duty to withdraw, did you withdraw? There is no such duty in Utah, but some states, they do require that if you have the ability to avoid or to leave, then you are required to do so. And finally, reasonableness. Would an objective, reasonable person have acted the same way you did? Those are the 5 elements of legal self-defense. Become familiar with those. They're very important. Should you ever be involved in a self-defense situation, you want to make sure that you fully take care of those elements of legal self-defense to cover yourself legally. Determining reasonableness, some things the court may consider: the nature of the danger, the immediacy of the danger, the probability that unlawful force would result in death or serious bodily injury, prior violent acts or propensities, patterns of abuse or violence. Other considerations: don't go chasing after a bad guy. You're not the police. When the police show up to a self-defense shooting, make sure your firearm is on the ground or in your holster. You do not want them to show up to a shooting and see you holding a firearm. Also, be the first person to call 911, even if you're justified in drawing your firearm. If the other guy calls 911 and says, some guy just pointed a gun at me, then police show up assuming you are the bad guy. Criminal versus civil liability. Criminal, the burden of proof is on the state beyond a reasonable doubt. Liability determined for criminal punishment, prison, fines, etc., usually always investigated by police. Civil liability, the burden of proof is on the party asserting the claim by the preponderance of evidence. Now, beyond a reasonable doubt is a stricter standard than preponderance of evidence. Basically, if there's 51% of the evidence, then that's a preponderance of evidence. Liability is determined to restore monetary or physical loss, usually always considered following the death of a person in the form of wrongful death or personal injury lawsuits. It's important to know that if you use your firearm in self-defense and are later tried and found not guilty of a criminal charge, you should understand that such a verdict does not preclude a civil proceeding against you. Regardless of the outcome of a criminal trial, you may become subject to a liability in a civil action. What is castle doctrine? This is something you may have heard of. Castle doctrine, also known as castle law or defensive habitation law, is a legal doctrine that designates a person's abode or any legally occupied place, for example an automobile or home, as a place in which that person has protections and immunities, permitting one in certain circumstances to use force, up to and including deadly force, to defend oneself against an intruder, free from legal prosecution for the consequences of the force used. Stand your ground sometimes is confused with castle doctrine. A stand your ground law, sometimes called a line in the sand or no duty to retreat law, provides that people may use deadly force when they reasonably believe it to be necessary to defend against certain violent crimes, the right to self-defense. Under such a law, people have no duty to retreat before using deadly force in self-defense, so long as they are in a place where they are lawfully present. The exact details vary by jurisdiction. Make sure you know what your local laws are in terms of stand your ground. Some jurisdictions do require that if you can avoid, then you need to. Or if you can retreat, then you legally are obligated to retreat before resorting to deadly force. The alternative to stand your ground is duty to retreat. In jurisdictions that implement a duty to retreat, even a person who is unlawfully attacked or who is defending someone who is unlawfully attacked may not use deadly force if it is possible to instead avoid the danger with complete safety by retreating. Justification of force. A person must reasonably believe that force is necessary to defend self or another against imminent use of unlawful force. Force that is intended or likely to cause death or serious bodily injury may only be used to prevent death or serious bodily injury to himself or a third person, or to prevent the commission of a forcible felony. In Utah, a person does not have a duty to retreat from threatened force in a place where the person has lawfully entered or remained. This is an important distinction here. Legally, bodily injury, serious versus substantial. Serious bodily injury creates or causes serious permanent disfigurement, protracted loss or impairment of function of any bodily member or organ, or creates a substantial risk of death. Substantial bodily injury creates or causes protracted physical pain, temporary disfigurement, or temporary loss or impairment of the function of a bodily member or organ. Please note, serious is worse than substantial. Serious is permanent, substantial is temporary. So the legal standard of self-defense, serious bodily injury, is permanent. Defense of a person must reasonably believe that force is necessary, defending against imminent use of unlawful force. May use force intended or likely to cause death or serious bodily injury if it's used to prevent death, serious bodily injury, or during a forcible felony. And again, no duty to retreat if you're lawfully there wherever you are within Utah. Forcible felonies have in common is its force against persons. So things like aggravated assault, mayhem, aggravated murder, manslaughter, kidnapping, anyway, quite a list of them there. So those are forcible felonies, and those you can use deadly force to stop the commission of a forcible felony. Remember, forcible is force against persons. Defense of habitation. You have a reasonable belief force is needed to stop entry or attack on habitation. If the entry is violent, tumultuous, or by stealth. If they're kicking your door in, that's a violent entry. By stealth could be, hey, they claim they're the UPS driver, and then once you open the door, they force their way in. That's by stealth. Well, if they enter with the purpose of assault or personal violence or commission of a felony, so examples of violent, tumultuous, or by stealth, kicking your door down, shoving your way in, pretending to be UPS. Use of force is presumed reasonable in your habitation if you acted out of reasonable fear of imminent peril, if the entry was unlawful and used force, or, as we said, violent, tumultuous, or by stealth, or to commit a felony in both criminal and civil cases. You have to prove to the courts or the responding officer that your actions were reasonable, that you believed you were in imminent peril. Defense on real property. This is defense of persons on real property. Same basic elements as defense of habitation. Reasonable, imminent, unlawful trespass, violent. You must be in possession of the lawful possession of the real property. Real property generally refers to land, structures, etc. So not just your home, but if it's a farm, you're out in the field, that's real property. You have the same presumption of reasonableness on real property. So force other than deadly force, if you reasonably believe force is necessary to prevent or terminate criminal interference. Property lawfully in your possession, the possession of an immediate family member, or possession of another whose property he has a legal duty to protect. Unjustifiable circumstances, things like you provoke the use of force as an excuse to inflict harm. If you're the provoker, then that's unjustifiable. Committing or fleeing in the commission of a felony, force to facilitate the crime or the escape. You can't claim self-defense if you were, committing a felony and on your way trying to escape, someone shot you or something. You cannot, it's also unjustifiable if you're engaged in mutual combat, unless the other person withdraws and effectively communicates intent to withdraw, and then attack still continues. You are justified in responding with reasonable force to these. Unjustified and unlawful force, things like assault, attempt or act that causes or risks bodily injury to another, Aggravated assault, attempt, threat, or act which causes or risks bodily injury to another and includes the use of a dangerous weapon. Threat of violence, threatens and acts with intent to place a person in imminent fear of injury or death. Arrests may be made by private persons for public offense committed in your presence. Reasonable cause to believe the person has committed a felony. But should you make an arrest, or should you try to be a good witness? Is it necessary to use force? Are you identifiable by responding law enforcement? You don't want the police to show up and shoot you. Secured or prohibited areas. So for Utah, places where you're prohibited from carrying a firearm, even concealed, even with a permit. There are airport secure areas, court secure areas, jail secure areas, inside federal buildings, correctional and mental health facilities, and houses of worship. In Utah, there is a law that a house of worship, a church, or other religious organization can designate, posting public notification that they are prohibited. So it's up to the churches to affirmatively decide that they do not want firearms, and then they register with the state as a prohibited area. A private residence, if notice is given, verbally or posted sign, and any area designated secure or otherwise prohibited by state or federal law. If notification has been given per statute, a person may not carry a concealed firearm into houses of worship, private residences, or private businesses. Personal communication, posting of signs, an announcement, publication in the newsletter, newspaper, etc. Those are how they'd notify. Other prohibitions, federal facilities, a building or part thereof owned or leased by the federal government, where federal employees are regularly present for the purpose of performing official duties. Indian reservations, you must obtain permission through tribal leadership. It's not applicable to highways passing through. And national parks and forests must abide by the laws of the state where the park is located. Traveling with firearms. In general, state laws regarding the possession of firearms vary. Always consider your travel mode, route, and destination, and understand state requirements before traveling. Air travel. Never attempt to travel with firearms in your carry-on luggage. Never. Doesn't matter if the intent was criminal or if you simply forgot you possessed a firearm. Best practice always to unpack before you pack. Make sure that your bags do not have firearms in it. Ensure your luggage and clothing are clear of any firearms or ammunition. Also, never use a range bag for a travel bag. Firearms and ammunition are only accepted as checked baggage. Must be declared to an agent at check-in. Firearms must be transported unloaded in a locked, hard-sided container. Declare each firearm each time you present it for transport as checked baggage. Firearm parts, including magazines, clips, bolts, firing pins, are prohibited in carry-on luggage, but may be transported in checked baggage. Most airlines do not accept firearms to be checked curbside. Only the passenger should retain the key or combination to the lock unless TSA personnel request the key to open the firearm container to ensure compliance with regulations. You do not have to use a TSA-certified locking device. You, as the passenger, the owner, should maintain possession of the key or the combination at all times. TSA does provide a number of resources to assist you. Just check their website. Check with the TSA, specific airport, and airline you're traveling with for exact rules and procedures. Alcohol and controlled substance violations. It's a violation to carry a dangerous weapon while under the influence of alcohol or a controlled substance. The state legal blood alcohol content limit, that's what it is. That's Class B misdemeanor. It is not a defense to say I've got a valid concealed firearm permit or licensed in the pursuit of hunting. If you are under the influence of alcohol, your blood alcohol content has exceeded the state limit. You cannot have a firearm in your possession. Prohibition of restrictions and confiscation of firearm or ammunition during an emergency. During a declared state of emergency, now this is in Utah, this is true, not necessarily in other states, so check your local jurisdiction. But during a declared state of emergency or local emergency, neither the governor nor an agency of a governmental entity or political subdivision of the state may impose restrictions, which were not enforced prior to the declared state of emergency, on the lawful possession, transfer, sale, transport, storage, display, or use of firearm or ammunition. And an individual, while acting or purporting to act on behalf of the state or a political subdivision of the state, may not confiscate a privately owned firearm of another individual. A law or regulation passed during a declared state of emergency that does not relate specifically to the lawful possession or use of firearm and that has attached criminal penalties may not be used to justify the confiscation of a firearm from an individual acting in defense of self, property, or others when on the individual's private property or the private property of others as an invitee. U.S. federal firearms regulations. There's a thing called a straw purchase. A straw purchase is when someone who can pass a background check knowingly purchases a firearm to put into the possession or transfer to someone who is a restricted person. So straw purchase, knowingly purchasing a firearm on behalf of a restricted person. Unlawful transport of firearm by non-licensed dealer, importer, manufacturer, collector. Unlawful transfer of a firearm to a restricted person. Unlawful possession of a firearm by a restricted person. These are federal regulations. And unlawful possession of a firearm in a school zone. Those can get you into federal trouble. Firearms on school premises. It is unlawful to possess a firearm at a place that the individual knows or has reasonable cause to believe is a school zone. The exception is if the individual possessing the firearm is licensed to do so by the state in which the school zone is located. In the state of Utah, public schools, a valid Utah concealed firearm permit holder can possess a firearm within a public school in Utah. Private schools can restrict firearms similar to how private property owners do. But public schools, public universities, they cannot restrict it if you have a valid Utah concealed firearm permit. Restricted ammunition, possession of armor-piercing ammunition and firearm capable of firing the ammunition during the commission of a crime of violence or drug trafficking shall be in addition to the crime of violence or drug trafficking crime carries a term of imprisonment for not less than 5 years. Federal firearm prohibitors. So how a person can become prohibited from possessing firearms. Any conviction punishable by a term exceeding 1 year. So that's not just felonies, but it includes pending felonies. If you are guilty of a crime where the punishment could be a year, more than a year, then you become a federal firearm prohibited person. If you're an unlawful user of a controlled substance, illegal possession, is a 1-year disqualifier, even if the case was dismissed or if you were found not guilty. Conviction of a misdemeanor crime of domestic violence, misdemeanor, no infractions. There's a difference between an infraction and a misdemeanor. Felony domestic violence would, of course, be denied as a felony. If you commit a felony, then you are a prohibited person. But these are some misdemeanors. So the crime must be a conviction. Domestic means that it requires an intimate partner relationship as defined by the FBI. And violence must involve an element of force. But if you are convicted of a misdemeanor crime of domestic violence, you become a federally prohibited person and cannot possess a firearm. If you are adjudicated mentally defective, you are prohibited for life, even if rights are restored or expunged. Exceptions, voluntary admits. So if you admit yourself to a mental institution for observation or evaluation, that's not adjudicated mentally defective. If you are forced by the government, by a court order, into a mental institution, that is an adjudicated mentally defective. Exceptions, voluntary admits in a mental institution for observation evaluation or receive ATF relief from disabilities under 18 U.S.C. 478.144. Protective orders. This is currently being adjudicated in the Supreme Court, so this information may be out of date depending on when you see this. Utah protective orders are non-expiring. There's no expiration date. In order to be prohibited person, the protective order has to have an element of cohabitation. Restraining orders from neighbors, stalking injunctions, whatever, are not prohibitors. If you are illegally or unlawfully in the U.S., you're prohibited. Dishonorable discharge from the armed forces, or if you renounced your U.S. citizenship. Those are federal firearm prohibitors. Definition of adjudicated mentally defective. A determination by a court, board, commission, or other lawful authority that a person, as a result of marked subnormal intelligence or mental illness, incompetency, condition, or disease, is a danger to himself or others, or lacks the mental capacity to contract or manage his own affairs. The term shall include a finding of insanity by a court in a criminal case, and those persons found incompetent to stand trial or found not guilty by reason of lack of mental responsibility. So those are some of the definitions of adjudicated mentally defective. And that is our summary of legal aspects involving self-defense and concealed carry.